advocate for all seasons. We're looking at sort of the impact of new technology, AI, different things on lawyering and defence counsel, being defence counsel for international criminal tribunals. I'm Yvonne McDermott-Rees. I'm a law professor at Swansea University in the UK, and I'm also on the CONI defence team at the SEC at the moment. In the interest of time, we're not going to do a big introduction of each of our speakers. You can see their full bios in the programme. And each of our speakers is going to speak for 15 minutes, and then we'll open up for questions at the end. So I know you'll all be bursting with your questions, but just hold that thought until we've heard from all of our three speakers. So without further ado, I'm going to hand over to Mylène Dimitri.
Thank you, Yvonne. Before I start, I have two confessions to make. So first, thanks all for inviting me and letting me talk about social media in the perspective of finding fair trials. But my first confession is I don't have a Facebook account, I don't have Instagram, I don't have a TikTok, and so I'm a bit lost. But I had to, as a counsel, I had to learn about social media and use social media to make sure that my client was afforded a fair trial, because a lot of the information was out there in open source and in social media. My second confession is that because we're talking about technology and because I'm going to address some of the super tools that the prosecution has and that we don't have because we do everything manually in our office, which for me is one of the fair trial components. I also wanted to sound or appear a bit prepared, so I wanted to have a PowerPoint, so, but I have no credit for it. My interns helped me putting it up because I thought it was important to show you in image the impact of, or the inequality of arms when it comes to social media. So thanks to them, they're here today. So the first thing I want to develop on is, I'm supposed to press, I think.
You might need to point it this way.
You see, and you should have been in charge of it.
There we go.
Okay. So the first thing I want to talk about is the various type of social media that is out there, or open source. In the trials, so back in the days when I was doing the ICTR trial, it was 1994, Rwanda genocide. There was nothing. There was no smartphone in Rwanda. So we barely had witness statement. If we were lucky, we could cross-examine the witness with some transcript of Radio RTLM or some newspaper of the Kangura Journal, or a previous testimony that they had given in Gacaca trials. Today, it's a different world. You start a trial, and there's so much evidence out there. There's so much in open source on YouTube, on TikTok, on WhatsApp, on Facebook. So you have to learn about them. You have to know how to use them, and you have to navigate through them, because some of the information out there can be very, very useful for your defense. When I first started the Yekaton trial, we spent hours and hours searching on the net for videos that were posted of mosques being destroyed to show that it was the local population and not the anti-Balaka. We spent hours and hours tracking down prosecution witnesses who were talking to each other on Facebook, and then we discovered that they were talking to each other on TikTok, some of them while they were in the middle of their testimony, claiming that they didn't know one another. So there's so much out there. and you need to exploit it because it's so useful for your client. But one of the problems is that you have to collect it yourself. So you have to spend countless hours searching through the net to collect all those videos, to collect all those messages from Facebook, and you have to analyze it yourself. And this is part of the disparity with the prosecution, who has an evidence collection tool, who you probably saw on, and I think it's on the next slide, you probably saw on the ICC website. So they have a form where everyone can upload information, videos, pictures. So imagine the amount of evidence the prosecution can receive in one case, and you, on the other hand, are in your office and you do everything manually. So you have a team member every morning, going on Facebook, going on TikTok, going on Instagram, trying to see if they posted a message, if they said something about the trial, if they spoke to each other, if they have a link, or if they even created a new Facebook account with a date of birth, because you heard from this morning we have an issue with fabrication of evidence and fraudulent group that created fake child soldiers in our case. So you have to do it every day, and so you have to create manually your evidence collection, which is one aspect of the unfairness and the inequality of arms. And not only that, you have to analyze it yourself. So when it comes to videos, and the prosecution in our case disclosed over 2,000 to 3,000 hours of audio-video material, because our client had the brilliant idea of inviting a journalist during the events to follow him everywhere. So we had to spend hours sitting with him and manually screenshotting every person that appears in the video to identify them, to know who is where, what's the circumstances of the video, what's the apparent date of the video, and this took us a year of work, 3 times a week, meeting with our client, going through the video, putting screenshot and creating our own database. And more often than not, the videos were in the local language, which was Sango, and the prosecution had not disclosed yet the translation or the transcription, so we had to do everything manually because, unfortunately, we are not there from the beginning, like Felicity said this morning, so we have to catch up. And our way to catch up was to create our own database, meeting with our client 3 times a week, and screening, analyzing those videos. So today, when we're writing the final brief, we have this huge database of the video disclosed by the prosecution, and we can search and easily pinpoint something that is important for our argument. On the other hand, the prosecution has tools that are not always at our disposal. I had a quick look yesterday. There was a tool that was presented in the Al Hassan trial. We, on the other hand, rather than having this hyper-tech tool that goes into the field and recreates the scenes, we went there manually with our little camera. We took pictures. I remember one day we had an individual alleging a specific event at a location, and we knew that there were exhumations at that location, so we wanted to make sure that it didn't correspond to one of the locations. So we sent our investigator in the field with his phone, tracking down the GPS of the location, speaking live to one of our legal assistants in office, and then once he found the location, taking pictures, taking GPS location, making sure it corresponded to an area that the investigator went, there was no exhumation. So we do all that manually, while the prosecution has access to all those tools, which is, again, a component of how it's unequal. You know, you don't have equality of arms if you don't have equality of tools. And you, the other thing I want to address in that, on that point is the power that the prosecution has when it comes to collecting private messages. So the prosecution has the hat of being the ICC prosecution. He sends a request to those social media entities and say, I want to have access to private Facebook messages because we're conducting a trial against Mr. Yekatom, Mr. Ngesona, and some of the individual may have been implicated in the crimes that are alleged, so we want to have access to the private Facebook messages that they exchanged contemporaneously. And then the prosecution will receive all those messages. You need to, again, analyze them manually. And I remember when we received, and I think we're talking about over 20,000 pages of private Facebook material, we again had to create manually a database where we scroll down through every single message, because you cannot use word searches because there's typos and because sometimes there's slang. So instead of saying, instead of using the full word, it's shortened. And because there is, sometimes they speak in their local language. So you have to scroll down through these thousands and thousands of pages and select what is relevant or material. And when you want to do the same, so when you want to access private social media because you think there's something out there, you have to send a cooperation request, and more often than not it's going to be rejected because you need to justify why you want to have access to private material. So we did that in the Yekatom case, but it took us several months because we had to collect a whole series of evidence that showed that there was this group colluding amongst each other before we could present to the chamber what we considered sufficient evidence of a group colluding amongst each other for the chamber to authorize the cooperation request and for us to finally receive the material from Facebook. And once we received the material from Facebook, not only was it was 20,000 pages of private exchange, but it also contained a lot of voice messages. So they were talking to each other via audio messages, and it was in Sango. So we again had to use our manual tools by going message per message to listen to what they were saying, asking our linguistic assistant, can you please, translate what is said, and then have a second person going through every message, because a lot of them were completely irrelevant, to select what we considered relevant to the case. And that's how we found out that they had fabricated evidence, because they messaged each other and you could see it in the private messages. But again, we did not have access to the prosecution's tools. So analyzing, collecting were not at the same level. And I wanted to show you, yes. And where I'm getting at is, and Phil and Kate and Anta might remember this. Back in the days at the ICTR, the prosecution was collecting material from various cases, whether it was the government case or the Kalimanzira case, which was a little bit connected to us in Butare, or the military case, and they had put a tool out there, a database where we could search for evidence in our various cases. And I remember it was an old computer in our office and we were sitting there, but at least we had access to their data. At least we could search I could search in her case, I could search in your case, for evidence that I could use in the Butare case. And I could download it or upload it or put it in a USB stick and then have a look with my client, or could we use this newspaper article that they're using in the government case. And when we came to the STL, it was a bit... I missed the sound timer on Marie.
Very subtle, guys.
Okay, 2 minutes. When we came at the STL, it was a bit similar. We had this EPE system that was available to the defense, so we could use the evidence that was disclosed to reproject it on EPE and do our own analysis. We also had access to the raw data in a room. It's not the same at the ICC. The ICC has a lot of material. I wanted to show you a video, I have no time. But the ICC receives all this material and they individually disclose in one case. So you heard a lot about the Yekatom and the Mokom case. I cannot search in Phil's case to see what's the material that the prosecution disclosed to Mr. Mokom, which is highly relevant to Mr. Yekatom. Neither could he. We have to trust that the prosecution meet its disclosure obligation. But in today's trials, when you look at today's conflict, 2014 or 2020 or 2024, the amount of social media, of open source evidence out there, the amount that the prosecution receives and analyzes through its various tools, it's no longer a question of we trust that the prosecution is meeting its disclosure obligation. It's a question of, obviously he cannot look in his material and understand that this piece is relevant or material for our defense. So it created an unbalance where we're now affecting fair trial rights because A, we don't have the same way to collect the material, B, we do not have the same tools to analyze them, it's becoming way too overwhelming for defense teams, and C, I can no longer trust that with all the evidence you receive every day, you're meeting your disclosure obligation. And I do not understand why the ICC has gone backwards, because at the ICTR, you had Rule 68, which you had the rule imposing on the prosecution his disclosure obligation, and you had the sub-rule, which says you have to give the defense access through your electronic database without prejudice to your disclosure obligation. But we no longer have that at the ICC.
Thank you so much, Renee. That was a very powerful presentation, and you never know, we might have time during the questions to bring up your video, but yeah, really interesting. So without further ado, over to you, Matt.
I've seen that video, it's worth watching.
Is that, oh, there's no microphone, is it?
Yeah. Thank you for having me today. As you can see from the introduction material, I'm actually working as a prosecutor at the Kosovo Specialist Chambers, but I'm not here today as a prosecutor. I'm here just in a personal capacity, so I'm not describing and can't describe what the SPO is doing or thinking in any way. But I personally have been really fascinated by artificial intelligence and international criminal law. I'm really grateful that Egil Talk published something of mine on this last year. And I'm really coming to you as an enthusiast more than anything else. I'm definitely not an expert. I'm not sure how many experts there are on this particular field, but I wanted to spend some time today talking about a very particular use case of artificial intelligence for the work that we do. Because AI solutions, they can help with a whole great many tasks. I mean, they can summarize email chains, they can improve your sentence quality, they can transcribe meetings, they can translate documents. There's all of these different things that it can do or could potentially do. They all have value. But I really wanted to focus on one particular application of this technology, and that is legal or evidentiary research. Just to do a little bit of level setting before I start, I need your help with an informal poll, if you don't mind. First question, we can just do it with a show of hands. How many people here have tried using an AI large language model like ChatGPT? Most overwhelming majority of the room. Of the people who have their hands up, how many of you have actually tried with ChatGPT to see if it can help you with some legal research?
Not ChatGPT, but something else.
Something else. Claude, Llama, Gemini, similar kinds of things. Not as many hands, but still a good number. Of those people, how many of you are satisfied with the results that the AI tool gave you? Now we're down to one.
Just me. Very limited expectations.
But I wanted to talk about this. People keep saying that this is transformative technology, it's going to change the legal profession forever, and on a day-to-day basis, it doesn't work. Why doesn't it work? Is it not ready? Is there something about the way we're using it we don't understand? This is something practical about this technology that I can't fully answer, but I wanted to sort of explore a little bit on this. Very basically, just as an overview on what a large language model does, these artificial intelligence tools are trained on truly unbelievable amounts of data. I mean, the most commonly used tools train on something that's representative of the publicly available internet. I mean, just unbelievable amount of content. And these tools, they get so much information that when you ask it a question, it's basically just doing pattern recognition to predict what words will come next off of the information that it has received. And in that way, it can kind of answer questions, but it is not thinking in the same way that a person does. These tools make mistakes that a human being would never make. And a lot of times that's because we are making certain assumptions, which we don't even recognize, when we talk to other people that can't be taken for granted with an AI tool. It's not like an omniscient being. It's more like some weirdly hyper-focused intern. It's like someone who can read and meaningfully describe 10,000 pages in a minute, but they don't understand why they're doing that. And it creates challenges to engage with something so unusual. And I'll go into a few of those challenges now. The first one is something that's called hallucinations, and this is maybe something many people in the room are aware of, even if you're not aware of the term. If you ask ChatGPT, what is the jurisprudence on some legal issue, you often get language that looks directly on point for your question. But then you go to the decision, the judgment, the quote you're looking for, it doesn't exist. It's very easy for an AI tool to confidently give the wrong answer. A second challenge is something called the safety layer. Just because it is mirroring things created by humans, artificial intelligence can have biases that are getting studied and are getting more and more commentary on. And one thing that companies like Microsoft and Anthropic, who run Claude, they don't want their LLMs, for highly understandable reasons, to be used for racist, sexist, hate speech, explicit content. And so they adjust their models so that it doesn't give back responses like that. And that is an eminently sensible principle, but when you're asking questions about murder or torture or forced pregnancy, the model may be catching it, and it may sanitize or censor the results in a way that is actually not helpful for an international criminal law practitioner. A third challenge is just a fundamental one of confidential information. Everyone that is working in one of these international trials is working with an extremely sensitive data set. And at least the publicly available AI tools, they typically need their data accessible online in order to work. And so certain information may be so sensitive that it can't be shared with an AI tool, even ones limited to training or analyzing a closed data set. A fourth challenge is something called prompting. One of the main advantages of these tools, if you've had experience with it, is your ability to refine the answers of the tool through chatting with it. And some risks of hallucination have been found can go down by asking more specific questions of the tool. Things like give a hyperlink with a source for your answer, go step by step in your answer. There's even some indications that telling the tool not to hallucinate helps not hallucinate. At least my own personal experience has been that prompting alone with a general purpose LLM still can't yield information at the level of a precision that an international criminal lawyer can really use. The final challenge I wanted to talk about is something called structured data. And this is something that really goes more to the heart of why these currently widely available tools aren't giving reliable results. It's the need that you have to structure the data that you're interested in for the AI tool to understand it. If you gave these tools fixed data sets and you explained where everything is within the data, then the quality of the results improves a lot. You can try this yourself with ChatGPT. Put like a single document, a PDF that's well OCR'd, and explain the document as fully as you can to ChatGPT, like where things are within it, require answers that are only drawn within the document, really try and explain and limit what you want it to say. The answers improve, the quality improves dramatically. It's not perfect, it's just an amateur attempt, but professional data management companies can structure data like that so that AI tools can actually produce specific quotes and citations. And I actually wanted to show an example of this in real life. There's a company called CaseText. It's an American legal research company, and they focus significantly on generative AI. And this is last year. This is a video. This is the CEO of CaseText in the upper right-hand corner, Jake Heller, and this is just a video that you can find on YouTube. But he's showing off what was then a new tool called Co-Counsel for CaseText. The video itself is just over 3 minutes, and the discussion that they're having is very interesting in and of itself. But he's prompting the tool to make a legal memo and do a document review. And so in addition to following the conversation, please also watch what the tool is doing during the video. And if it helps with the timestamp, it's from the 3:20 mark to 6:47, and we can play it now.
We programmed Co-Counsel to have a number of legal-specific skills. The 6 that we're launching with are things like asking to review documents, to do legal research, to extract data from a contract, to summarize large and lengthy difficult documents, other similar skills. So to give you a sense of how this works in practice, I might ask my AI to do legal research for me and say, what is the standard allegations under the False Claims Act in the Ninth Circuit? I'm just talking to this like I would a colleague. What's happening behind the scenes is it's deciding what search queries to run based on this query. It is running those search queries against our database and daily updating cases, statutes, rules, and regulations. It is reading hundreds of results that come back from these searches, and then it's going to use that to put together a legal research memo in response.
How can lawyers who are using this know that the result that comes back is reliable?
It's a great question. The short answer is 2 pieces. The first is I'll kick off a document review project that's kind of similar. Uploading 33 speeches that Barack Obama's given, and you can ask any questions in it. Does Obama make a joke? Does Obama mention his daughters?
Does he mention his dog?
Does the speech include veiled criticism of Republicans? What this is going to do is bring back answers relatively quickly. It's also going to empower you to find the exact page where it claims it got the answer from for you to verify for yourself. For all of the skills, it's going to answer questions based on the case that it is itself reading. It's also going to answer questions based on the documents that it's reading. So you can verify that entirely yourself. There's also another set of things that we do on the product side to make sure that it's answering based solely on the information that it's reading, that it's not pulling from extraneous information from its memory. Already it's pulled dozens of cases. We'll, in a moment, kind of start writing its reason why it believes this case is relevant for every single of these cases.
In addition to actually generating the memo, it's also showing you the cases from which it has drawn the expertise in the memo and the sections of those cases that are relevant.
That's exactly right. You can see it now is currently typing out its memorandum. This is the kind of work that, as an associate, would take me hours. It's giving me its deep and nuanced based on the crew.
I think some people worry that this would replace a lawyer, but really what it's doing is giving you an extremely good place to start with the memo as well as the cases, so that you can go and look at them and tweak the memo and save many hours of time that you would have spent. It still requires the human to look over it in the end and ensure that it's expressed the way that it would like to be expressed.
To go a step further than that, first of all, I think that lawyers empowered with this are going to be able to do so much more, so much better, and so much faster for their clients that they're going to be in much more demand and going to be put in a position to do really great work for their clients. I think that's going to be really empowering. They're not going to see less work and see a lot more demand for their work at a cheaper, lower price. I also think it's actually knowing what questions to ask and knowing what to look for in documents, what to look for in the cases, how to conduct their legal research. I think the new skill is going to be about deciding how do you delegate to this incredibly powerful asset that is going through hundreds of thousands of pages of text incredibly quickly. So, for example, for every one of these, it's saying, did Obama make a joke? He jokes about 900 remarks in front of him and also uses a later tone to talk about his presidency.
That additional information is so critical for lawyers and so useful to get that on the page.
Exactly. It's kind of explainability, including pointing to the exact right page in the case, and even open up the page for this speech to confirm or deny is a really critical aspect of working with this kind of AI.
I can see that in some cases it said.
Thank you for that. I find watching things like that in action to be incredible. And that particular tool, it's only available to legal professionals in the United States. It's also a tool that's pretty much only focused on US law. As an interesting postscript to that video, within 4 months of it, that company got bought by Thomson Reuters, who are the Westlaw people, for $650 million. There is no technological reason why this can't be done on the ICC Legal Tools Repository or HUDOC or the ERMIT case law database. It's a challenge of structuring the data, closing the data set, and setting up the tools so that it can do these things. It is a transformative technology. It's not like a maybe someday transformative technology. It's transformative now. The next steps are to resolve the real and the significant challenges that we face to make these things usable in the modern ICO world.
Thank you. Thanks, Matt. I've got loads of questions and loads of thoughts on the interface between your two talks, but I'm going to, in the interest of time, hand over to Sarah, and then we can open Catherine. And then we can have questions at the end. Thank you.
Okay. Good morning, good afternoon, everyone. My name is Sarah Zarmsky, and I'm an assistant professor at Queen's University Belfast School of Law. Full disclosure, I'm coming at this completely as an academic. I'm not defense counsel, but I have a lot of research background in a lot of what I think Len was talking about with open source investigations and fair trial rights and new technologies in that sense. I've been asked to present today on what I just finished as my PhD, which is international criminal law ready to accommodate, I say, digital harm. Today I'm just focusing on online harm, and I'll get to that just in the interest of time. So digital harm perpetrated via digital technologies. Online harm is a subcategory of this, so this is harm perpetrated by just the internet, online means. A lot of what I'm saying today is reflected in my article with the JSCJ from May of this year. And I think, it might be useful for defense counsel in the sense that it's kind of a look at what might be coming in the future. A lot of the offenses that I'm going to be talking about have already been tried and prosecuted and resulted in convictions in domestic war crimes jurisdictions. So I think this might be a good look into the future. So of course, online harm can encompass anything online. So it could be cyberbullying, cyber harassment, child pornography, and the like. But my research only focuses on examples relevant to international criminal law, specifically the core international crimes, crimes against humanity, war crimes, and genocide. So some examples that I've explored, these are not all of them, but hate speech and disinformation online, online terrorist propaganda and sharing footage of crimes online, and online sexual violence. So just the images here are, I'm sure we might all be familiar with the hate speech that has been rampant in Myanmar on Meta, and the case at the ICJ, the Gambia v. Myanmar, that focuses a good amount on this, and of course the recent application for arrest warrants in that situation. So that's an example of online disinformation and hate speech that's been allegedly fueling atrocity crimes. The other is a clip from the murder of the US journalist James Foley in 2014. He was beheaded by ISIS, and the video was posted by ISIS onto YouTube and circulated and went viral. So these are two examples that I focused on in my research, and I'll get more into them. So I guess I'm not going to spend too much time on this because I think a lot of the people in this audience would know why acts are criminalized under criminal law, and specifically international criminal law. But the main question here is, why should we care about online harm or digital harm when we have things like genocide, mass killings, torture, things like that going on? And the answer to this, I don't necessarily agree with all of these, but these are the three theoretical lenses that you can answer that question. So to prevent harm, because it might warrant punishment, deterrence, or expressivism. So sending a message to broader society that these harms perpetrated by new technologies are continuing to be important, and that there are victims of these that we should be trying to get justice for. But the overall conclusion that I make in most of my research is that in many cases the online component exacerbates and often extends the harm. So, and this is key in a lot of these domestic cases, which is that instead of having an isolated killing, for instance, if it's then filmed and then spread online, you're exacerbating that harm with insulting the dignity of that person further. Their family might see it, innocent users might stumble across it. And then also it's, available, once it gets online, it's essentially impossible to remove anything once it's hit the internet. It will always get reposted somewhere. So then it's kind of permanently ingrained in the online space, and that can just extend the harm beyond that isolated crime. So in my research in this article, which forms kind of chapter 2 of my upcoming book on this, I kind of do this comparative exercise, comparing the harms of these online or digital harms alongside the harms previously recognized in international criminal law jurisprudence and in the elements of crimes. So, for instance, for online hate speech and disinformation, I think this is probably the most straightforward one because it's very similar in terms of, hate speech has been prosecuted before as a crime against humanity and persecution, or as incitement to genocide, dating back to the Nuremberg trials. We were talking about this, but it's just with a new forum, so it's in an online context. And arguably there, it can even be, worse in the sense that it can reach a much wider audience in a much shorter amount of time than, a flyer in a public square would. Or even radio broadcasts if we talk about, the Rwandan media trials. So here are just some examples, like I said, Meta in Myanmar, but there is also, rampant COVID-19 disinformation that went viral in the United States that's been, alleged to cause a lot of deaths. It can also encompass election interference, so Russian bots spewing disinformation to skew the results of the US election, which some scholars argue could be a form of aggression. I'm not sure I agree with that, but that's an example. And of course here we did have prosecutions of, magazines, newspapers, radio, transcripts at the ICTR cases. And so here I think it's pretty plausible that we might see this at a court like the ICC in the future. The second category, I say sharing footage of crimes online because it's not just terrorist beheading videos in that sense, or terrorist propaganda. So here there are the typical ISIS execution videos, like the James Foley one I showed, where they upload it. Like terrorist groups have a YouTube account designated It's also happened more and more increasingly in the Russia-Ukraine context and in the Israel-Palestine context, where individuals who witness crimes or actually soldiers who are committing the crimes are filming these crimes and then bragging about them or posting them on TikTok, Twitter, Facebook, etc. And so here, this has actually already been prosecuted in multiple domestic jurisdictions. So in the Netherlands, there are Syria cases where a man was convicted for posting photos of himself next to a crucified body to Facebook. And he was convicted of outrages upon personal dignity for that, in addition to the other crimes. This has also occurred in Sweden, Finland, and in Germany, so this is kind of a trend that we're seeing. Mainly, it's been the war crime of outrages upon personal dignity, but in my research, I talk about how it could technically also fulfill elements of inhuman treatment, willfully causing great suffering, other inhumane acts as a crime against humanity. There's also, this isn't really a Rome statute crime in that sense, but in the Geneva Conventions, there is a prohibition regarding public curiosity, which is expanded upon in a recent ICRC commentary. So these are definitely things that could also come into play. I think the two most, less obvious ones here are torture and persecution. So here, torture I write about because you wouldn't really think about it, I guess, on the surface, but actually there is case law that I listed there where the courts ruled that the presence of onlookers or having crimes committed in front of others, especially your family members, or when family members or acquaintances of others are forced to watch attacks on other people, this has been ruled as meeting the threshold for severe mental suffering as torture. So this is something, even though you're watching it through a screen, I think, it could come up in the future in a prosecution regarding, filmed and shared footage. And then in terms of persecution, this type of act has also been used to persecute minority groups. So, for instance, ISIS groups have repeatedly put up videos of them throwing gay men off of buildings, and so this has been used to instill fear and, ultimately infringe upon the fundamental rights and liberties of the gay community in that sense. So that's also been argued to constitute persecution. So this is kind of a theoretical exercise since it hasn't happened yet, but in terms of war crimes of outrages upon personal dignity, this has happened in multiple domestic jurisdictions. And then finally, online sexual violence. So this can be things like, I think it can be both the act, similar of sharing the crimes online. It could be sharing nude photos of someone or videos of someone without their consent, which, we might have heard of as revenge porn in many domestic jurisdictions. It could also be, if there's like a picture from someone in a conflict zone where they're not clothed, even, without that intent of revenge porn, it could still constitute this non-consensual nude image distribution. But it also could be things like online sexual slavery marketplaces, where this has occurred in the context of the Yazidi genocide, where they had these kind of online, like eBay-type marketplaces with everyone's personal information, and they were selling women into sexual slavery. So here, I think, kind of straightforward, but the crimes against humanity are war crimes of sexual violence and also outrages upon personal dignity, because sexual violence at its root is sort of about that assault on personal dignity and autonomy. And here, again, these relevant cases are where when others had their sexual acts watched, or when they were forced to watch sexual acts, the court said that it was an act of sexual violence against that person. And even when this was in a sort of non-sexual context, so in the Akiyesu case, there was a female who was made to undress and do gymnastics naked in front of soldiers, and this was ruled to be sexual violence, even though it wasn't necessarily something like rape or forced marriage or something like that. The fact that she was nude, it made it that sexual sense. So here, I think, again, the court has recognized this harm of, being watched, this assault on dignity, and the humiliation that comes with that, and I think this could come with some of these online harms. So the next question would be, what are the means of criminalizing this under ICL? How might we see this happen? I argue that the most feasible avenues will be that prosecutors can group these under existing offenses, because a lot of them are similar in nature, but of course the challenge is that doesn't allow for accountability for harms and redress for victims where the harms aren't similar enough to those encompassed by existing crimes. So in this presentation, I haven't really gone over all of the digital harms that I talk about in my research, but there are proposed crimes such as digital apartheid, and cultural genocide in that sense, like the destruction of a cultural group, which is happening with mass surveillance in Xinjiang, China, allegedly. So these are other crime, or I don't want to say crimes, but acts where it might not be similar enough to something that we already have to be prosecuted, and therefore might need a new crime. And these things could also be considered as aggravating factors during sentencing, or could be considered during the gravity assessments at the ICC, for instance. And then less likely, I write possible, but I'm not really sure it is, the addition of a new offense, like what was done for ecocide, which hasn't happened yet, of course, but there is that Rome Statute amendment process that could potentially happen for something like digital apartheid or a very technology-centered crime. So moving forward, I guess this is also the more relevant bit for defense counsel would be the digital evidence challenges. So here, a lot of these were illustrated by Len, but when you have digital harms, you're likely going to have some form of digital evidence. So here, there's a lot of challenges that come up with this. First of all, the authentication of open source information, so in an era of deepfakes and, even just mistaken context. So, I know in my work with Yvonne, we've talked about the Syrian hero boy example from 2014, I believe, where, a video went viral on very mainstream news outlets who probably should have checked this, claiming that this boy was in the rubble in Syria, but it actually was from a film set in Malta. This has happened, in the Russia-Ukraine context where video game footage has gone viral for being real, but it's actually from video games. So it's not always that it's fake or, manipulated in that sense. It just can be mistaken context on the video. So this is obviously something that is a challenge because you need to have reliable, authentic evidence for prosecutions and also in the interest of fair trial rights. Also acquisition from social media companies. So a lot of times, of course social media companies will not want to hand over the information, but on top of that, they often remove the content pretty quickly because if it's graphic or violates their terms of use. And then it's really not clear what happens after that. So in terms of preserving it for courtroom use and admissibility standards, such as chain of custody, it's not often preserved in a way that we can be confident what's happened to it since then. And that goes with the adequate retention of data. And then also with the online sphere, you have this issue of anonymous perpetrators, which could come into play with fair trial rights, of course, because it might be a lot harder or a lot harder of an analysis to make to know that someone actually did post something online. So there's a lot of anonymous accounts that post things, and then the ways that we find them aren't always reliable. So things like IP addresses and finding the server, it's actually not as reliable as the science sometimes makes it sound. And then again, like I said, ensuring fair trial rights. I've been working on this with my colleague who's former defense counsel, Judy Miyake, on a paper researching extra considerations for defense counsel for open source evidence. And there we do list some of the things that the previous panel mentioned. So, having the defense involved in an earlier stage. I know that we discussed sexual and gender-based violence trainings, but, trainings for open source evidence, how to, authenticate open source information on your own, or, of course, if we can, raising the budget so that you could hire your own experts to do this. I also think, we talked about Project Harmony and OTP Link. So OTP Link, maybe the defense having access to that repository of the information, although you have to be able to sift through it, which is another problem. And just keeping the defense involved in discussions with technology companies as the technological developments progress at the International Criminal Court. And then these are some other challenges: meeting the gravity threshold, and then ensuring that the right to freedom of expression, especially with online speech-based crimes, is respected. But my time is up, so thank you.
So much. Thank you, Sarah. I'm conscious we haven't done the round of applause for any of our speakers, so let's do it. I'm going to open up to the floor for questions. Just to kick things off, I have one question, I think, in terms of a theme that I saw across the three presentations, which is the issue of bias. So, if we think about how bias can impact on technology and international criminal law, we can think about three forms of bias: so cognitive, technical, and access bias. So I think the access bias comes into some of what you were talking about, Sarah, like what do we see? And I was also thinking, and like what gets attention, but I was also thinking about how disinformation can actually fuel particular narratives online. Milene, I think this is something you've raised in your case, and you know how that might, it actually might be a defence issue, disinformation as well as potentially within the bounds of a crime. And then, Matt, I was thinking about the technical bias side, I suppose, and particularly about under-resourced languages. So how does this kind of thing work when we're thinking about Sango, for example, where they don't have these lexicons of languages that can feed in and train the AI? And then Milene, I was thinking about cognitive bias, and you mentioned the 3D models that the prosecution has, and how that could be seen as somehow more convincing than your poor investigator going with their iPhone trying to record something. So yeah, do you have any thoughts on bias? Maybe we'll go with that order. Sarah.
Yeah, I mean, like you mentioned, bias is a very critical issue. I think I, explore a bit. I have a piece on the digital reconstructions used in the Mali cases at the ICC and the bias that could come into play there. I think it's especially important to consider bias that goes into, while AI tools can help, and like I found Matt's presentation to be really interesting and I think could be really useful, we do have to remember that these tools are made and coded by humans, and so their biases are going to be in there. And there is this kind of seeing is believing effect where we tend to place undue reliance on things that look really technologically and scientifically fancy. So I think these are things that while we do want to use technology to help us and to help lessen the workload and the burden, especially on the defense, I think, keeping in mind that these things are not flawless, even though it can be really hard to detect those flaws when you're not an expert, that's another major issue.
Yeah, and at least at the level of, on the technical side, at least to the extent that I'm aware, there is certainly the potential for these tools to cause biases, particularly if you're not aware of them. And it's not something that I think can ever be eliminated. I'm actually not aware of any research technological medium that doesn't have bias within it, but it's something to be aware of, it's something that needs to be addressed, and it's something that it needs to be challenged. I think a lot of the stories where legal applications of AI went wrong, and you can find that news story in lots of different guises over the past year and a half, they often come from people putting too much faith in the tool. And they don't challenge it, and they don't check it for themselves. We know that facial recognition has a racial bias. You shouldn't just assume that an AI application of something is going to give you an accurate result. On the part of under-resourced languages, there is some indication that not every language the AI tool responds equally well, and it does slant towards the languages that have more of a presence on the internet. On the one hand, we tend to work in courts that have working languages of English or French, which are well supported by the models, and so maybe some of the issues with the Sango evidentiary collection may be resolved by needing to make an English or French translation of those things, which is an obligation in trials, but that doesn't help you when you're collecting information. And a lot of I didn't even talk about the use of it as like an open source, intelligence tool. There's lots of ways to use these things where the language can become more problematic.
You can have, more often than not, prosecution presenting videos or open source material, trying to convince the judges, for example, that the individual that you see on the video looks so young, he's under 15, so to support the charge of child soldier against your client, or that a certain individual who's giving a very violent hate speech against Muslim is part of your client's group, and your immediate reaction could often be biased. You could often say, yes, he definitely looks like under 15, and you saw the Lubanga case, how it all went down on the video. And this is again the importance of giving a reasonable opportunity to the defense to have access to what's out there. You said it earlier this week, Yvonne, you said that For the Syrian conflict, there was more there was more hours on YouTube than the actual conflict. So imagine the resources or the material out there that you can use, and which again comes down to how we used it in our defense case, because through this video that the prosecution was using to show that a certain individual was either was a member of our client's group because of the violent speech he was giving, or the individual that looks under the age of 15, through hours and hours and hours of research, we actually found the individual, and he was 16 years old, and we found another video, and by looking at the metadata, because I think it's how you spoke about the importance of the metadata that are often stripped out when it's put online, we realized that the journalist was actually very far away from our client's camp, and so the individuals that she was interviewing and who were having who were using these violent language were not from our client's group.
Thank you so much. Okay, I'm going to open it up to the floor for questions. Questions for any of my panel?
Hi, I'm used to practicing in the U.S., so my questions may be a little provincial and not exactly aimed toward international practice. But with respect to both Facebook and YouTube and all of the other socials that are out there, at the beginning of a case, is anybody sending a notice for preservation to the companies to say, do not toss this stuff, hold on to it, we're going to need it?
That's a great question.
I'm not counsel in that sense, so I don't have the most recent perspective, but I can just say that some companies, like Meta, for instance, I can't say they actually follow through with this, but they do have huge human rights reports policies where in there it says that they'll cooperate with accountability mechanisms for crimes and human rights violations, including international crimes. So in theory, they should be doing this, but in practice, I don't think that is the case.
Yeah. Maybe you want to come in at the experience of that cooperation.
Well, I think it's a great question. I'm not sure I have the answer. What I can tell you is, from a defense perspective, by the time we come in and we start looking at the material and thinking, you know what, I want this Facebook account, or I want access to this, it's too late to react. So and what the prosecution will look at is different than what we will look at. So they will try and collect material that supports their case, rather than material that affects the credibility of the witnesses that they ultimately decide to call. However, I have seen the prosecution disclosing and using Facebook material where the individual actually erased a phone call, because apparently you can call via Facebook, a phone call in the Facebook history, and you could see that after his testimony, or during his testimony, there was this instance, according to the prosecution, and then they used it against the credibility of that particular witness by saying, well, you see that there's an appearance of we can see that he erased the phone call or the message, probably an appearance of guilt or conscience of guilt. So that's the only answer that I can think of.
Felicity. I think there's also an issue of takedown. So the social media companies often take material down that violates their terms of service, and that can be sometimes if it's violent or bloody in content. And their position is, once it's gone, it's gone. We don't. We know now that that's actually not true, because there have been instances where the Syrian Archive Project, for example, were able to say, hang on a sec, they woke up one morning and 400,000 videos from YouTube had just been removed, and this was really important evidence of crimes in Syria. And after a lot of negotiations, they were able to get that material back up online. But the problem is increasingly algorithms do this kind of work, so we don't know what we don't know. You know, there's a risk that things just won't get posted, and then we can't ask for them to be just goes through. Sorry.
This might be a statement more than a question, but
Oh, sorry.
I'll see if I can frame.
I don't need it, I'm really loud. See if I can frame it as a question, which is, have you come across this, that the prosecution have used an external expert, or the court has required the use of an external expert to examine witnesses' phones, where much of this evidence would be. The prosecution have got what they want, and then the defence are not given access at all. And even then, if the defence can persuade the prosecution to agree some sort of questions for the expert, the court will then say, oh, that will take too much time, we're not going to allow it. So one of the real issues is not having access to the phones that might actually contain that information. So I don't know whether you've come across that as a problem, and there is a lot more detail, but I think that's a serious worry.
Did everyone hear the question? Or did everyone hear this? It was basically about access to mobile phones and
Well, for those who know me, Felicity, I'm very pragmatic. And in order to avoid this type of problem, I had come across a witness who had valuable information, and I'll try to not reveal anything confidential. I believe most of it is now in the public domain. And so I showed him through the phone. So I was speaking to him through my fixed phone at the ICC, and I wanted information that was contained in his phone. And so I showed him how to extract himself the whole history of conversation he had with a particular individual and send it to me. And then we submitted it into evidence. And then so that's the first example. The second one is, so in the course of the trial, when we discovered this fabrication scheme with some prosecution witnesses, registry intermediaries, prosecution intermediaries, at some point the registry organ came across a phone from one of the alleged child soldier, and so the story is the following. The scheme involved registry prosecution intermediaries, and we had discovered that one of the individual was, let's say, I'll put it in very general terms, was linked, had family links with an intermediary that was hired by either the prosecution or the registry, and that when he came to testify, he used a fake identity. But we discovered his real identity with investigations, and because of all our filings, at some point the registry section dealing with protective measures came across his phone, and there was a message to the intermediary, and he was referring to him by using the family link connection. And so the registry disclosed this information. So we said we want a full search of the phone, because there's probably much more information out there. If the protective measures section only came across this message, we want a full search. And the prosecution objected. So it's good for them, but when it comes to us, they object.
I mean, again, for me, I've been in cases in the past where this issue has arisen. Sometimes I've even seen problems where you go too far in the other direction, and digital devices are, like forensic copies are given to defense teams, and then defense teams have challenges as, what do I do with this? Like, this is a giant repository of information that's been given. There's no way for me to be able to understand what's within this device. And that you have a situation where even where there is an equality of access, there's a differential level of understanding what is in the digital device. And sometimes there have been solutions about proposing keywords and doing searches and actually doing some more inter partes steps to try and understand things within the collection. I'm hoping, I mean, this is another sort of application of something like an evidentiary research AI solution, because it's a large data munching thing. That's really the biggest advantage of the tool. And I would like to think that it might facilitate everyone's understanding of these kinds of things.
Any other questions? Yep, it's on the back.
First of all, thank you for the brilliant discussion. I had a question directed particularly at Ms. Dimitri's comment about how it was hard today to trust that disclosure obligations were met because of the wealth of evidence that's available out there. Would you say that certain AI tools, as the ones that we've discussed today, if they were to be developed, could restore your confidence in the prosecutor's ability and willingness to systematically review evidence and disclose it where needed? Or would you say that even that wouldn't be sufficient because perhaps of prosecutorial practice or various issues? Thank you.
Thank you for your question. I think I'd rather look myself rather than counting on an AI tool, although I find Matt very convincing and how to tweak them to get them to do what you want. But I think what I'm trying to say is that I want to draw a parallel with, you have all these decisions, and there were some in the Sudan case, in the Abdelrahman case, recognizing the importance for the defense to go on the field in Sudan to investigate. And today, the field is there. It's out there on the internet. The prosecution has access to it. They collect it. They have all these tools. And you want to be able to search in their database. So if you can conduct investigations in the field, why can't you conduct your investigations in the prosecution's database? And I think this is what I'm trying to aim at, because, of course, you cannot always compare equality of arms with resources, but when it comes to today's conflicts, you have to ask yourself, in those conditions, with every material, with the amount of material the prosecution receives, does the defense really have a meaningful opportunity to conduct an investigation and to defend their client if they have to do everything manually? And that's why I'd rather have access to their database. Of course, they can redact, or they can apply, they can do it or give access to the defense while still applying or following the rules on confidentiality and privacy and all of that. But we're not the public. We're part of the system. But nowadays, in order to have equality of arms, I want to be able to search in their database, because this is a field of investigation for me.
This reminds me of a question that came to mind that I had for all three of you, which was about sort of practicality, practical solutions. So, Milene, I suppose one practical solution to all of this would be that the defence gets access to everything. Another might be, is there a role for the Defence Office, the OPCD, to have something similar like the OTP has, which is, you have a go-to person, you've got this video, you need to geolocate it. That individual doesn't need to be assigned to a particular defence team. Is that a possible solution, or is it in the makeup of defence teams? Do we need to, now that you also have a language assistant, but now you need to have an open source assistant, or I don't know what you would call them, a digital investigations assistant? And on practicality for Matt, I was thinking about, you mentioned the ICC legal tools, and I don't know if it's other people's experiences, but I find searching for case law really difficult, and trying to find the ICC website is a complete mess if you're looking for decisions. So I wondered, do we think we're in a space where we're ready to lift from those data sources to train this data, or what would be needed as an interim step? And then Sarah, for you on practicality, I was wondering about what do we think the ADC, the ASP, what are state parties' opinions on online harm? Is this something that states themselves are moving
I can go to the question to me first. I don't know exactly what you need to do to get ICC legal tools to work. If I did, I would have a different presentation, yes. But I can say that, I mean, I've also shared the struggle of trying to find things like that. A lot of the challenge comes from setting up the database in a way such that an AI tool can understand. If you watch Milen's Project Harmony video, which I encourage you to do, it's the ICC OTP's kind of initial recitation of what they would like AI to do for them. And if you watch the video all the way to the end, you can see that the people helping them are 3 companies. It's Microsoft, it's Accenture, and Avanade. Avanade is actually just a joint venture of the first 2 companies. Microsoft you've heard of. They are a heavy investor in ChatGPT. It makes sense in why they would be involved. Accenture is actually, it's a data management solutions company. They help structure data. That's what they do in this context. And Avanade is an AI-specific version of what Accenture does. And so it's trying to get your system to be understood by the AI tool. And there are certain ways that this is done nowadays, but a lot of them, as you can imagine, are for for-profit companies. Like if you have a U.S. tax form, you can get an AI tool that can very quickly be able to read those things. They're all written in a very standardized way, and the tool has been trained on them. Or a receipt. But I mean, an ICTY trial judgment is not something anyone has invested the time to structure so one of these tools can train on it. And that is a significant limiting piece right now.
Yeah, I remember, does anyone remember the Charles Taylor judgment came out? What was it, like 2,500 pages, but it wasn't, you couldn't do a control F on it? It's like, oh, so yeah, we have some time to go.
Legal aid, yes, of course, but it goes back to Philip's problem. There's no money in legal aid. So today, if with the current legal aid system, if I were to ask CSS to hire a specific tech guy to go through the social media, to look at, to use his expertise, I bust the budget with one query. I had it at the very beginning of the trial because we were trying to look at satellite images, and our expert was telling us, well, I need to buy this catalog and you don't have the budget for it. So we had to rely on the satellite images that the prosecution disclosed. OPCD, yes, I think Marie has a Christmas list. So maybe we can add that on her Christmas list. Marie, I'm going to send you an email on Monday, and maybe you can convince the prosecution to open a specific room with all the evidence collection, and we can all go and search in there.
Yeah, if I can first comment on Matt's question as well. And going back to the question that was asked in the back earlier about the OTP using AI, I've done a bit of a deep dive on this, and they actually are using AI to sift through the materials that OTP link gets. And they've said that they're using a software called Relativity One, which if you go to Relativity One's website and look at the fine print, they are powered by the same AI as OpenAI, which, I mean, take that what you will. Like, I'm not sure I trust OpenAI, again, a for-profit company who's known to have a lot of bias in their AI technologies, to be sifting through my evidence. That's something to keep in mind. In terms of states' opinions on online and digital harms, there are a ton more, bills that are happening, like online harms bills in the UK. Digital harms are, being criminalized in many jurisdictions, like I said, in those domestic war crimes cases, but also, there's a lot more legislation, for instance, on like nude images, non-consensual nude images, deep fakes being used for malicious purposes and things like that. So I think it is definitely something that ICL would be hopefully maybe catching up to in the future, and we'd have to pay attention to.
Thank you. Any more questions, comments from the floor?
Yes, just one thing about this AI and finding evidence and looking at evidence record with robots or whatnot. I want to talk about the experience in Macomb, where down the line, it's a prosecutor reading that and refusing to acknowledge that the evidence is actually exculpatory. So I don't think there's no level of robots or automatization that you can put in if you cannot deal with, I think, the worst bias of all, which is the prosecutor's bias. You know, a prosecutor, il y a personne de plus aveugle que celui qui ne veut pas voir. And that was the reality in Macomb, that pointing at, we had 6 months to prepare with a great team of lawyers, including Kate, and reading that and saying, but what the fuck? This is exculpatory evidence to say that this guy created a military police to rein in the anti-Balaka. This is exculpatory material. And there were hundreds of mentions like that. And we had to fight for months with that prosecutor, receiving insulting letters about us telling him that he had not done his job and that he needed to go through his record to actually identify the exculpatory parts of the evidence they had in their possession for years, and on which they justified the arrest and detention of Macomb for 19 months. And after these insulting letters, the pretrial chamber finally ordered him, now it's enough, you're going to do it as you were ordered to do it years ago. And then they changed the prosecutor. And then someone with maybe a less narrow tunnel vision starts looking at that, and here it goes. Every day we were receiving exculpatory evidence that found in those hundreds of thousands of pages that we did not have the time to read all in such a short period of time. But the miracle of it all is that they had 3 weeks to do it, and we were receiving, in average, between 20 and 30 new pieces of exculpatory evidence every day. And all of a sudden, at the expiration of their delay, bam, it stopped completely by miracle, that they had managed to do it all in that time frame, which I will never believe for a minute. So what I'm saying is that this is why Mylène is so right, that we need to have access ourselves in their database and to look with our perspective and our opinion and our instructions and our investigations at their data set to be able to show how shit are their cases. Because if we don't do it, nobody will do it, and they will continue to spend millions of dollars on useless cases. So we're there for that. They don't want to pay us, but that's okay. There are enough motivated people that will continue to do it. But I think, and we were doing it at the STL. We had access to their database, and we were able to work on the same field as the prosecution. What is the ICC prosecution trying to hide exactly? I'm not sure, but I'm very interested in trying to know, and I think we should push hard to have equal access to their database. We are officers of the court. We can be bound by protective measures. We will not put it on social media or share it with AI or whatever, but I think we need to push hard to be able to do that, because I think without that, there will be no fair trials, and they will continue to arrest arbitrarily and random people for no good reasons. Thank you.
Thank you so much, Pradeep. Anyone else? Any final comments, questions, thoughts from the floor? Okay, in that case, I'll leave it to each of our panelists to say anything you'd like to say wrapping up.
Well, I think we should go back to step one, which was the ICTR and the STL, and we need to change the rules of procedure to give the defense access to their database in order for us to now be able to meaningfully investigate within the new evidence that we have now, which is out there in social media.
I mean, the only thing I wanted to end with, it's just so interesting to talk about technological evolution that is just at the beginning of it. I'm very interested in people that have been practicing law longer than I have, when they went through the advent of the internet, which was another transformative technology. And I think a lot of the discussion and challenges and even fears about AI now, you can find older versions of people having the same concerns about the internet. many of which came true anyway, by the way. The internet can be transformative and difficult to deal with at the same time. And I've been very grateful to get to chat with you all about it.
So much. And Sarah has very kindly ceded the floor because we're the last thing that stands between all of you and lunch. So once again, just want to thank our brilliant panelists for a fascinating discussion.
On the topic of lunch, if you have purchased lunch, you will find your ticket at the back of your name badge. I'm told this year the restaurant is upstairs. I don't know what that means yet, but we'll find out together. For those of you who don't have a ticket, we are resuming at 2:30.